So welcome to this webinar hosted by Bristows, Data Protection in the EU, Russia and South Africa. I'm Robert Bond, I'm here in our London office, and shortly you will be hearing from Andrey Zelenin from Lidings in Russia and Ridwaan Boda from ENSafrica in Johannesburg. And I'm going to broadly leave the EU issues to the end because I think many of you have heard us talk about GDPR more than enough times. But we felt that today's webinar was relevant because it's not all about GDPR. There are other interesting regimes. And why have we got such a big focus on data protection? Well, 40 years ago, we didn't have any of these things. We didn't have telex, if anybody can remember what telex is or was. We certainly didn't have email. We certainly didn't have the internet. In fact, none of these things existed. And the laws which we had 40 years ago, if we had any at all, were based upon the fact that data moved physically in paper, in boxes from A to B, whereas in fact now we have data moving from anywhere to everywhere. And it's inevitable, therefore, that there has been a growth in different frameworks around personal data. It's not all about GDPR, and I wanted to mention that if you ever want to understand how the law may be interpreted or influenced in different parts of the world, think about the historical influences, think about empires and commonwealths and the way in which the law has developed. And it's not surprising, therefore, that there is a big European influence in the Middle East, that North Africa is very French influenced, that Argentina is very Spanish influenced, that the UK influences many parts of the world. And so we thought that it would be useful today if we took a look at what is happening outside Europe in the sense of two major jurisdictions that banks, insurers, mining, technology companies all reside in and all have to now adjust to new regimes. Ridwaan Boda is going to talk about the South African overview. And Ridwaan I have known for many, many years. Indeed, recently I visited his offices in Johannesburg where we did some presentations to South African companies on a compare and contrast between POPI, the new law in South Africa, and GDPR. And so I'm delighted that Ridwaan is going to talk through this in a moment. And then he will be handing over to Andrey Zelenin from Lidings, a law firm in Russia with whom we've had good relationships over the years at Bristows. And I'm delighted that Andrey is going to be looking at what is happening in the current data protection regime in Russia. So this is being recorded. A recording will be available after we finish the webinar. Please, by all means, send your questions in using the question box, and I will put them to the presenters as appropriate. But I'm now going to ask Ridwaan, unmute Ridwaan, and over to you.
Thank you very much, Robert, and thank you all for having me today. As Robert mentioned, I'm Ridwaan Boda. I'm the head of technology, media, and telecommunications law at ENSafrica. ENSafrica is Africa's largest law firm. Next slide, please, Robert. In today's session, I'm going to be providing an overview of privacy law developments in South Africa, as well as just a very brief historical development of POPI, the Protection of Personal Information Act, which is the key piece of legislation which seeks to govern data privacy and protection in South Africa. Finally, I'll touch on a compare and contrast of POPI as opposed to the GDPR. Next slide, please, Robert. So the Prior to 2013, South Africa did not have any privacy laws in place. The laws are governed mainly by the Constitution of the Republic of South Africa, which provides that everybody has the right to privacy. There were sporadic pieces of legislation which made privacy and data privacy more of an ad hoc and non-prescriptive nature. Until 2013, when finally, after 9 years of development and 13 iterations, the President of the Republic finally signed the Protection of Personal Information Act into law. In terms of POPI, however, there were only 2 sections which became operative, both of which relate to the formation or the appointment of a regulator known as the information regulator, and also certain definitions and empowering provisions to enact regulations. Next slide, please, Robert. So subsequent to the president signing the legislation into law, only 2 sections of the legislation have become operative. And we are still, as at today in 2018, awaiting promulgation of the remainder of the sections of the Act to be in full force and effect. The POPI regulator, or the information regulator, was appointed in December 2016. And last year, in 2017, the regulator finally published draft regulations for consideration. As at today, we are still awaiting the remainder of the provisions of POPI to become operative, as well as the draft regulations to become operative. We suspect, and the regulator has provided guidance to say that anywhere between now being April 2018 and November 2018, that the remainder of the Act and the regulations will become operative. Once the Act and the regulations become operative, there will be a transitional period of 1 year within which companies need to comply. Next slide, please. Much like so, POPI was is based on the old EU directive for data privacy, and much like the EU directive, it makes provision for certain stakeholders. The first being the data subject, that is the person to whom the personal information relates. Next is the responsible party, also known as in some jurisdictions as the data controller. And this is the private or the public body or any other person who alone or in conjunction with others determines the purpose and means of processing personal information. Thereafter is the operator. The operator is also known as a processor in certain jurisdictions. This is the person who processes personal information for a responsible party in terms of a contract or mandate, but without coming under the direct authority of the responsible party. And then finally, there's the information regulator, who, as I mentioned, was appointed in 2016 and has now issued draft regulations for consideration. Next slide, please. Much like the EU model, POPI defines personal information in the broadest of terms. However, the one key differentiator of POPI as opposed to other pieces of legislation is that POPI does not only apply to living natural persons, but it also applies to identifiable existing juristic persons as far as possible. So POPI does not only seek to protect the rights of individuals, it also seeks to protect the rights of companies, of trusts, of close corporations, and of other juristic entities which have been created under South African law. Next slide, please. The term personal information is defined in the broadest of terms, and it relates to everything from race, gender, sex, pregnancy, marital status, to education, or medical, financial, criminal, or employment history, also to things like identifying numbers, symbols, email addresses, biometric information. Next slide, please. Personal opinions, views, or preferences, the views or opinions of another individual about a person, correspondence that is implicitly or explicitly of a private and confidential nature. So it's defined in quite broad terms. And as we see today in South Africa, on a daily basis, every single person in any organization or any party processes personal information in one form or the other. So the Act is quite widely defined. Next slide, please. The next key term which POPI, which is defined under POPI, is processing. POPI provides that a responsible party must process information by adhering to the 8 conditions for lawful processing, and in that way will process personal information in a lawful manner. Processing, again, is defined in the widest of terms. Any adjective that the regulator could have thought of, the legislator could have thought of to define processing, they have included. And this, again, is based largely on the old EU directive. Next slide, please. Processing of personal information applies to both public, which is state institutions, as well as private bodies, which are private companies. It applies to any information that is entered into a record, if it's recorded by an if it's recorded by automated means. If it's recorded by non-automated means, i.e. a paper-based system, such records must form part of a filing system. POPI also extends only to responsible parties who are domiciled in the Republic of South Africa, and also to parties who are not domiciled in the Republic of South Africa, but using non-automated or automated means situated in South Africa, unless South Africa is used as a mere conduit only for forwarding of personal information. So if you are a company and you have a back office operation in South Africa or a call center operation in South Africa, you're a company from Europe or the United States, you may not have a physical presence in South Africa, but by the mere fact that you are processing personal information in South Africa, you would be caught by POPI, and POPI would apply to you. Next slide, please. POPI does not regulate certain types of activities, the first being pure household or personal activities. POPI also does not apply to any information that has been de-identified, but with a proviso that that information must not be capable of being re-identified. So if it's purely statistical information and information cannot be re-identified, then POPI would not apply to that specific information. POPI does also not extend to any law enforcement body in South Africa providing any sort of law enforcement function. That's the national security, any defense force, the South African police services, the prosecuting authorities, and any other body which provides any public law function related to security. And then finally, POPI does not apply to processing for pure journalistic purposes, provided, however, that journalists are subject to a code of ethics that provides adequate safeguards for protection. So if you have a random blogger who wishes to claim to be a journalist, that blogger would not be able to rely on the exclusion under POPI unless that blogger is subject to some form of code of ethics that provides adequate safeguards for protection. Next slide, please. As with the EU directive, POPI provides that responsible parties must process information in a lawful manner by adhering to what's known as the 8 processing conditions. Again, this is very similar to the EU model, and the principles around or the conditions which data responsible parties must adhere to is that of accountability. So data controllers or responsible parties must comply with the 8 principles. There is a purpose limitation, so data should only be obtained by limited and lawful processing that does not unnecessarily infringe privacy. There's also a purpose specification, so the purpose for which personal information is collected must be specific, explicitly defined, and lawful. There's also limitations around further processing activities. Next slide, please. There's also an information quality requirement. Next slide, please, Robert. Then there's an openness principle. There's a proactive duty on responsible parties to notify the regulator if there's been a data breach. In certain instances, there would also be a registration requirement with the regulator in South Africa. POPI also maintains provision that personal information, responsible parties must take proactive steps, reasonably proactive steps, to ensure the integrity and confidentiality of personal information. And finally, the last condition is that there is an element of data subject participation. Data subjects have the right to certain access rights, including the right to request deletion of certain personal information. So much like the EU directive, POPI is modeled on which POPI is modeled on. The 8 processing conditions would apply to any responsible party seeking to lawfully process personal information in South Africa. Next slide,
Ridwaan,
please.
Ridwaan,
Yes.
it's Robert. Just got a question come in for you, so I thought it was appropriate to say, you mentioned exemptions, one of which was household purposes.
Yes.
Somebody has said, can you explain more what that means?
So it's actually one of the curious provisions in POPI. There is no further direction which has been provided in the Act. The Act merely says that POPI does not apply to pure household activities or activities of a personal nature. So we would assume it would not apply, for example, to a husband exchanging phone numbers of a friend of his with his wife or something like that. So it's personal information exchanges or processing within the context of regular household activities. Unfortunately, there's not much more direction or guidance from the regulator as to exactly what household activities mean. So for now, we taken a very literal interpretation, limiting it to households only. Whether it extends to things, for example, like a gentleman interested in a lady and wishes to obtain the lady's phone number from a particular friend of his, whether it extends to such activities remains to be seen. But for now, we've taken a very narrow literal interpretation of what household activities entail, and hopefully the regulator will provide further guidance in the future of going forward.
Thank you. Okay, please, sorry to interrupt.
Not a problem. Thanks. Next slide, please. So as I mentioned, late last year, the POPI regulator published draft regulations for comment. In honesty, in all my years as an attorney, I have not seen such horribly drafted legislation, and that is not my personal view only. I think most commentators who looked at the draft regulations late last year were actually quite shocked at how badly the regulations were drafted. Thankfully, the regulations were in draft format, and there was an opportunity to make representations last year in November, and we at ENS made representations on behalf of a number of our clients, especially in relation to direct marketing, which the draft regulations seek to cover. There's also provision in the draft regulations which makes the processes for requesting deletion or correction of records more clear. The draft regulation also expands on the duties of the information officer. So unlike the GDPR, where appointing a data protection officer is not always mandatory, currently in South Africa, under a different piece of legislation called the Promotion of Access to Information Act, every single organization is required to have an information officer. And by default, private bodies or private companies would have their CEO as seen as the information officer, unless the CEO has delegated that function to another person within the organization or has outsourced that function. So POPI actually seeks to expand on the duties of the information officer because PAIA, the Promotion of Access to Information Act, already places a requirement on organizations to have an information officer in place. POPI now expands on those duties, and it's quite prescriptive in what processes and duties the information officer must follow. So it's everything from implementation of a risk management framework to ensuring that the responsible party and its staff undergoes awareness training and conducts training sessions amongst its workforce. Also, the information officer is required to put in place policies related to data subject access requests, and also to make what's called a PAIA manual available on the responsible party's website and at its workplace. So another differentiator between POPI and most other companies or jurisdictions in the world is that under South African law, in terms of the Promotion of Access to Information Act, there is a requirement for most large companies and most governmental departments to have what's called a PAIA manual published on its website. The PAIA manual consists of details of the actual body, so the corporate structure. It also includes the name of the information officer, how any person wishing to make an access to information request should contact the information officer, and it has certain standard forms which should be attached to the PAIA manual. POPI now seeks to increase the content of the PAIA manual, and amongst the items which companies are now required to disclose in their PAIA manual is what processing activities are being conducted by the company or body, to which categories of data subjects are processing activities taking place, is the body engaged in any transborder transfers of data or information, and if so, to which jurisdictions. And then one of the alarming provisions is that the PIA manual, which is, as I mentioned, must be on the company's website, must contain provision which allows any third party to make an objective assessment of the security measures employed by that company to protect such personal information. So that's actually one of the more ridiculous provisions emanating from the draft regulations. We're hoping that the draft regulations or the regulator will listen to the comments made by a number of parties about the concerns related to the draft regulations. But if the regulator listens to the constructive criticism which has been made, we hopefully will see a much better quality of regulations coming out in the next round. There is no date as yet for the next round of draft regulations to be published for comment. But if the regulator does not heed the concerns made by a number of parties, I think it's going to make compliance with the regulations very difficult. It's going to particularly affect direct marketers, and it's also going to be quite onerous for information officers to comply with the provisions of POPI. Next slide, please. So that is the draft regulations. As I mentioned, we don't have a specific date for the next iteration of the draft regulations. We will publish a news brief as soon as we do hear anything on that, and I'll share it with Robert as well. So moving on to wrap up what POPI contains. So if there's non-compliance with the provisions of POPI, any person or any aggrieved party may lodge a complaint with the regulator. The regulator may try and secure a settlement. If no settlement is possible, the regulator may initiate an investigation, and based on the investigation may issue an enforcement notice. It should be noted that if a regulator issues an enforcement notice and a responsible party does not adhere to the enforcement notice, the information officer can face jail time or a fine or both. So that's quite that's quite a notable provision under POPI as well as PIA, the Promotion of Access to Information Act. And then finally, the data subject and or the regulator may sue the responsible party for damages. Next slide, please. South African courts historically are not that generous. So unlike the US, where you'll find large quantums being awarded by courts, South African courts have always been much more prudent when it comes to awarding damages. However, the Act does make provision for a court to award damages for monetary and non-monetary loss, aggravated damages, interest, and legal fees. And then finally, the Act does impose criminal sanction on organizations, and responsible parties or their board of directors can face 12 months to 10 years imprisonment or a fine or both. 10 million rand is roughly just under $1 million, probably about $900,000 US. But it is quite a substantial amount for South African companies in the event that there is a fine issued. And that in essence wraps up an overview of POPI. Next slide, please. I'll then move very briefly on and conclude with a brief comparison between POPI and GDPR. So some of the similarities between POPI and GDPR is that the processing conditions under POPI are very closely aligned to GDPR, including the accountability, lawfulness, and transparency principles, which is known as openness under POPI. The purpose limitation in the GDPR is known as the purpose specification under POPI. Provisions around data minimization, accuracy of data, retention obligations, and security safeguards over personal information. The other similarities is that POPI also makes special requirements in relation to the processing of special personal information, including the information about children. And POPI also makes provision for appointment of an information regulator, which is not too dissimilar from the supervising authorities in Europe, such as the ICO. Next slide, please, Rob. And then finally, some of the material differences between POPI and GDPR. For one, and probably the biggest difference, is the scope of application and the persons to whom information applies. So currently, as I mentioned, POPI applies to personal information processed in South Africa, whereas under GDPR, personal data of all EU subjects, regardless of jurisdiction, applies. POPI applies to both juristic persons and to natural persons, whereas GDPR applies to natural persons only. The terminology is fairly similar in that we have a responsible party as opposed to a data controller. We have an operator as opposed to a processor. However, GDPR does make provision for joint responsible parties, third parties and recipients, and POPI does not. The penalties under POPI, as I mentioned, 10 years imprisonment or 10 million rand fine. Under GDPR, it's much more severe. It can go up to 20 million euro or 4% of worldwide turnover. In terms of officials, it's a mandatory requirement for all bodies to have an information officer in place, irrespective of the size of the body, whereas under the GDPR, data protection officers are only required for certain types of organizations. When it comes to breach notifications, POPI says that the responsible party must notify the regulator of a breach as soon as reasonably possible, whereas GDPR places more of a prescriptive amount of time, and it says that breaches should be reported to supervisory authorities within 72 hours of discovery. Privacy by design and data protection impact assessments are not addressed by POPI, so it's not mandatory requirements under POPI. Although we do see that more and more companies are starting to embrace this as best practice in the local jurisdiction. And then finally, under data portability, data subjects have certain access request rights, including a right to request records in a reasonable manner and format and in a form that is generally understandable. Whereas under GDPR, the right for a data subject to receive his or her data in a structured, commonly used, machine-readable, interoperable format, and the right to transmit that to another controller does apply. So data subjects can order that their data be transferred to another controller or service provider. That's under GDPR, whereas under POPI there isn't. The other minor differences, or the other differences, GDPR does make provision for the right to be forgotten, whereas POPI does not. And that, in a nutshell, is just a synopsis of South African legislation, South African law as it stands today, and a very brief comparison between POPI and the GDPR. If there's no questions, I'll now hand over to Andrey. Thank you very much.
Andrey, all yours.
I'm here. Hello, everyone. So I'm Andrey Zelenin, a managing partner at Russian law firm Lidings. We're very much focused on providing services to foreign business in Russia, and hence we're quite well aware of the recent attention the Russian personal data law has received from various international businesses. Next slide, please. So, as Robert has explained at the outset of the webinar, there is a lot of influence between various jurisdictions nowadays, and Russia is not an exception. In this sense, we have followed the European path, and for quite a while, since 2006, we had a personal data law in place, but the way it has been implemented was rather scarce until late 2014, where significant amendments have been introduced into the law, basically a single amendment, but quite significant for international business, which required that the personal data of Russian individuals is not only collected in compliance with the law, but also stored and processed in Russia. So that explains the recent attention the law has received from many of our clients and other companies globally. So what is personal data under Russian law? Quite similarly to GDPR and POPI, it's any information pertaining to a particular identifiable on the basis of such information natural individual. Well, you'd see that the list is quite broad. It's information on facts, events, or circumstances of his private life, such information that allows to identify an individual, including some recent additions from court practice data on the date, death of a person, mobile number, email, photo, etc. Next slide, please. Who is hit by the data protection law? Mostly it applies to an entity which qualifies as a data operator that is any person which is doing any action with personal data, including gathering, systematizing, accumulation, storage, refinement, use, etc. There is no concept of data controller or data processor under Russian law, and as I've mentioned already, it has certain extraterritorial effect. It always applied to any person operating personal data of Russian citizens. There is one exception that I would touch upon in the next slide, but the basic principle is that whenever there is a Russian individual involved, we should think of compliance with the Russian personal data protection law. What are the basic requirements? The data operator at first should receive a written or electronic, or as the law says, any other consent for personal data processing. Quite a few exceptions. This consent is not required for performance of a contract to which the individual is a party. So it's a simple, if it is a simple contractual relation, you should not require such a consent. But at the same time, there is a more strict requirement of written, that means physical written consent for special personal data categories like religious belief, health, and a number of others. Personal data operator ensures the confidentiality of collected personal data, and the process of collection and the actual data which is collected should be relevant and not excessive in relation to a particular purpose which is required by a particular personal data operator. And in terms of regulatory side, a personal data operator is required to notify the Russian controlling authority, which is abbreviated as Roskomnadzor, which is a supervision agency on Russian communications. Next slide, please. So, how does it work? Before you start processing personal data of Russian nationals, you should be making this notification in a specified form. The register is publicly available online, and there are already more than 400,000 of personal data operators registered. Our recent experience shows that the authority acts quite proactively, and what we've seen from a number of our clients is that they would be sending on their own initiative like prompting letters to particular industries, for instance, to IT companies, to pharma and healthcare companies, inquiring whether they have already included themselves in the personal data operator register, and if they have not, what is the reason for that? And this activity of the authority is explained by quite significant sanctions which follow the non-compliance with the Russian law. A number of exceptions on this slide, which is useful to keep in mind. The exceptions are related to personal data of employees of a company. Again, the personal data related to a contract with an individual. Personal data which has been already made publicly available by an individual. And quite an important one, if personal data consists only of a surname, first name, and a patronymic. As you might know, Russian names consist of 3 parts. It's not considered as personal data for the purposes of notification. The reason for that basically is that you cannot identify an individual 100% with only his full name. And another exception, which sounds quite weird nowadays, but if the personal data is processed without using automated IT systems, you should not be doing this notification if someone is still doing that paper-wise, like Robert outlined at the very beginning. Next slide, please. Personal data operators are obliged to process personal data using servers located in Russia. That's the principal localization requirement in the law. Where and how does that apply? For instance, you are an international company which collects data on customers and consumers from various jurisdictions. If you are targeting Russian individuals in your web engine or whatever, you have to ensure that the personal data of these clients is collected and stored using Russian servers. You have an exemption in the case the access to personal data from abroad, while the personal data are stored in servers in Russia. So it's still possible to access this data from abroad. And again, one important exemption for a global company is you are collecting personal data in relation to a Russian citizen within the territory of a foreign state. Well, that normally goes to offline, but imagine a Russian consumer filling in a certain form in a retail shop somewhere in Europe. As long as this is done within a territory of a foreign state, that does not qualify for localization requirements. Next slide, please. As I said, the effect of the law was something to be expected, and last year we had the first and for the time being the only case where a huge international company, social network LinkedIn, has been found in compliance with the Russian requirements to localize personal data, and via court procedure, the Russian authority has blocked access to LinkedIn from Russia. So basically, this case shows that any foreign online platform which is collecting personal data of Russian users and which it doesn't comply with these localization requirements is in breach of Russian laws, and hence has this risk of the internet site and access to its online services being blocked in country. Next slide, please. In terms of transfer of personal data outside of Russia, so again, it should be done in compliance with the personal data localization and other requirements set out in the law, and also adequate protection of personal data in corresponding foreign states should be ensured. So theoretically, Roskomnadzor would investigate how do foreign laws on personal data protection work, and Strasbourg Convention on Personal Data Protection Matters comes into its attention. This requirement can be lifted when you receive a prior written consent for a transfer from the individual, and again, the transfer of personal data is made on the basis of a contract with an individual. Next slide, please. Some basic requirements for processing personal data via internet. Personal data operator should have its privacy policy published on its website. The contact form, which is usually used to collect personal data, should be relevant to the purposes of the processing. A special personal data officer should be appointed who would be taking care of the compliance with the regulatory requirements. As mentioned already, mandatory notification of the Russian controlling authority is required, personal data localization, and there is a special requirement forbidding processing of biometrical and other special categories of personal data. Next slide, please. One other recent case, which is not directly connected with the personal data protection law, but is connected with personal data, is a dispute between a Russian Russia-originated social network, vKontakte or VK, with the Double Data, a local data mining company which used profiles of the social network users to evaluate the credibility and sell that to the National Bureau of Credit Histories, basically for the purposes of further evaluation if they're eligible to be granted with a credit. So there was no consent either from the social network or from a particular user, and because of that, VK filed a lawsuit to restrict this use of its database. They lost the case in the first court, but then the appeal court, Double Data has been obliged to stop commercial use of this personal data, which has been connected without the consent of social network users. So basically, what comes out of this court decision is that personal data from public sources can be collected and used only for the purposes for which they have been provided, so for social networking and not for selling that further to some other entities. And even if such use is in compliance with the this general purpose, this should be a separate and explicit consent of that individual, that user, either through the rules of the social network or via a direct relation with this third party. Next slide, please. Yeah, the liabilities that I've mentioned, apart from the risk of the website to be blocked for Russian users, there are also some monetary fines. Some of them are related to violation of labor legislation related to employees' personal data, and you can see the figure on the slide. It's 150 euro. Data security regulations, that's 400 euro, and seizure of the facilities, which means servers. And most recently, last July, there have been amendments and 7 new offenses were introduced related to the new personal data law, including the requirements for processing, legalization, etc., with a number of fines where the penalty has been increased from quite a minor amount of 10,000 rubles to 75,000 rubles, which is something above 1,000 euro at the moment. Next slide, please. A couple of other cases which are related to use of technology and personal data in Russia. The so-called right to be forgotten. Again, no express connection to personal data protection law, however, quite actively used nowadays by individuals seeking to delete certain information on the web. There are three main categories: information which is in controversy with the Russian legislation, misleading information, including that which is inaccurate or irrelevant, and outdated information, which has lost its value for an individual due to certain subsequent events or acts. The process is quite straightforward. So there's an application of the Internet Service Engine doesn't comply with this request, the individual will have a right to apply to court and force the Internet search engine to delete information. Next slide, please. Well, again, certain administrative responsibility would be applicable here if the search engine refuses to delete a web link. Next slide. Yeah, finally, I think that's the last slide I'm having here, is certain regulation related to news aggregators, which is related to a software website which is processing and distributing news in Russian via internet. So it's an extension of mass media law to such engines like Google News, for instance, which would be collecting information from Russian or foreign mass media and making them available as a digest at their internet webpage. So the requirements are as follows: that kind of service should be doing verification of the information published prior to its distribution, preventing news which are defamating to Russian citizens, and store the published news within 6 months. Next slide, please, and I think that's the last slide with my contacts. Thanks a lot.
Andrey, before we carry on, there's a couple of questions specifically for you, so I'm going to put them to you now. In one of your early slides, you talked about being caught by the law email, and we've had a question that says, in Russia, is there no exception for email addresses?
Well, the email address itself doesn't qualify as a data which makes an individual identifiable, unless it's quite a detailed email and you'd have all the whole information in that. But an email together with the name basically makes it personal data. Okay.
And the other question was, can you store the personal data of your employees outside of Russia if you're an international business that processes that data internationally?
Well, in this case, as I've mentioned before, you do not qualify as a personal data operator, so you should not be doing notification to the Russian controlling body, but you should be storing information in Russia. That doesn't prevent you for making a sort of a mirroring scheme on the consent of employees and in compliance with the Russian personal data law requirements. But the initial collection and storage of this information should be made within Russia.
Okay, thank you. And I've got some other questions for both you and Ridwaan, but I'm going to leave those until I've finished the last few slides, and then we can do some compare and contrast. So going back to GDPR, and obviously Ridwaan's slides very properly did a compare and contrast with POPI. For those of you that haven't looked at GDPR, and I'm assuming all of you are acutely aware of it, I'm telling you what you already know, which is personal data has been widened here to now include, much like POPI, biometric and genetic data, but it also applies to both controllers and processors, and is extraterritorial in that it applies to any business anywhere in the world, even if it has no legal entities in Europe. If it is selling goods and services into the EU or actively monitoring citizens in the EU. We have this notion of a one-stop shop, that instead of dealing with 28 member state regulators, we'll only deal with the regulator in the main state in the EU where you make decisions in relation to data. In reality, we're finding that there is no such thing as a one-stop shop, because for many multinationals, they have different entities with their own autonomy in different member states. So I don't think the concept of one regulator is really working. We have the mandatory data protection officer, as Ridwaan alluded to, but not for every business. And so that's where there's quite a difference. And I want to come back in a minute to talk about the information officer or the data protection officer, because that's where all three of us have issues to address for our clients. GDPR focuses on more principles of transparency and accountability, which is driving businesses to demonstrate compliance themselves, and less by having to talk with regulators, at least until it goes wrong. We certainly have the new concepts which do not exist, we know, in POPI, of privacy by design and data protection impact assessments. And of course, we have the increased fines. What we also have coming along is the e-privacy regulation, which is almost a double blow because it is now extending the opt-in approach to both consumer marketing as well as business-to-business marketing. The soft opt-in is likely to go. The fines for non-compliance with distance marketing mirror those within GDPR. And we were hoping, as lawyers in Europe, to see the draftspersons of e-privacy soften their stance, make e-privacy regulations the same as GDPR. But unfortunately, as you can see, the recent issue around Cambridge Analytica and Facebook has prompted our European Data Protection Supervisor to start focusing even more on the need for strict e-privacy rules. And this, I think, is going to be an area we need to watch because, again, it's making or is likely to make it much harder for the ad tech, the marketing, the list broker communities, indeed anybody that wants to carry out a digital business, to be able to carry it out without seeking permission. It's not all about consent. There still are some other lawful grounds for processing, but very, very briefly, because of time, here we are in the EU with less than 50 days to go before GDPR comes in on the 25th of May. So we are working very hard with an increasing number of international clients with no physical presence in Europe, as well as clients with legal entities in Europe, to look at the key issues, reviewing third-party vendor contracts to make sure they're compliant, understanding the touch points, the points at which the individual connects with the business, whether it's through the website, through apps, through interviews, through job applications, through exhibition and convention, dropping of the business card in the fish bowl to win the prize type situations, and saying we need to have more plain language and transparent and intelligible information notices to tell individuals this is what we do with your data, these are your rights, etc. We're having to work to develop accountability documentation, everything from the data privacy impact assessment to the how do we manage data subjects' rights, the right of portability, the right of erasure, etc. And then governance, because policies and procedures are no use without appropriate training. And that's a new area that is being developed, is to make sure businesses can demonstrate that people saw the policy, agreed to the policy, understand what the business's approach is to data privacy compliance, both legal and ethical. And finally, IT systems play a huge role in managing data management, managing the segregation of different data when it was collected, either with consent or legitimate interests and so on. We've heard about the enforcement regimes in both Russia and in South Africa, but I wanted to finish with that dam breach or that dam breach, because I think, and I'd be interested to see what my fellow panelists say, that we will see a significant increase in consumer actions against businesses, because GDPR allows consumers to seek compensation not for financial loss, but for nothing more than emotional distress if they believe that their rights have been damaged by a data incident or by misuse or mis-selling, etc. And I am sure that we will find no win, no fee US-style firms bringing actions, as well as, of course, the company facing investigations by regulators and so on. So with that, I'm going to go back to questions. I wanted to ask Ridwaan, and then I'm going to ask Andrey just to comment. My understanding is there is a need for some officer in Russia, the data protection officer. There's the information officer in South Africa, and we have the data protection officer here. Ridwaan, does the information officer have personal liability?
Yes. So when one looks at the way POPI seeks to amend PIA, the Promotion of Access to Information Act, the amendments do create personal liability for the information officer. So as I mentioned earlier, PIA is the enabling legislation which gives effect to the appointment of the information officer. POPI expands on those duties, but in passing POPI, the legislator has actually sought to amend PIA. And what the legislator contemplates is that if there is an enforcement notice issued by a regulator, and if the responsible party fails to comply with such notice, the information officer will be personally held liable, either criminally or through a fine. So there is scope for personal liability for the information officer in that instance. There's also potential for further liability if the information officer is obstructive, if a regulator conducts an investigation and the information officer fails to cooperate with the regulator, there is potential for further personal liability. So in those instances, there is scope for personal liability.
And again, Ridwaan, does the information officer have to be physically based in South Africa in the business?
Not necessarily. So the default is that the chief executive officer of if it's a private company, is the information officer, unless the chief executive officer delegates that function to somebody else. POPI and PIA are not prescriptive to say that the person must be on site or must be physically present. So there is a potential to outsource that role, or to appoint, a global information officer who also doubles up as the information officer for South Africa.
Okay, and Andrey, how would you answer that from the Russian point of view?
Sure. Well, there is definitely a personal liability in terms of fines and other restrictions imposed on an individual who has been appointed as an officer. And though there's been no actual court practice yet in place, but normally the administrative offense would work in a way that you would receive a fine for the company and a smaller fine for an individual who's been responsible for making the company compliant with the law. Same as Ridwaan has just mentioned, by default, it's the general manager of the company, unless there would be a specially appointed individual. And no, there is no requirement for someone to be physically located in Russia. Otherwise, it doesn't really play well with global digital companies. At the same time, I can imagine that there is limited chances for enforcement of such a fine to a foreign individual unless he appears in Russia at a certain point.
Well, I have one more question, and it sort of follows up from that. So I'll start with you, Andrey, and then I'll get Ridwaan to look at this. So let's suppose that you have got a member of the board, or indeed the person who is the data protection officer, who is situated outside Russia, but the company is investigated and held liable, and the officer has liability. Do you see them being extradited or forced to appear in Russia? If
well,
they're overseas?
that's not a criminal offense, so it's unlikely that extradition procedures would be used. Again, I think for the time being, it mostly goes like a declaration for foreign individuals, largely directed at local entities or again, international companies which have set up a local entity and have a local officer appointed in Russia for these purposes.
Okay, and then Ridwaan, the question actually came in specifically after things which you had said in terms of liable to imprisonment. So how does that pan out if the information officer is actually outside the jurisdiction, or the board is held personally liable?
So in theory, the South African government can initiate extradition proceedings against that individual if they're in a foreign state. That's a theory. In practice, however, our law enforcement authorities are not the greatest when it comes to prosecuting offenses. There are exceptions when there's high-profile murder trials like the Oscar Pistorius trial, which happened a few years ago. Because of the media scrutiny, the law enforcement authorities were quite diligent. But generally, our criminal justice system has a lot to be desired in this country. And whilst the theory is, yes, there is a potential for extradition proceedings, whether in practice, the National Prosecuting Authority and the information regulator would go to that extent, whether in practice that happens, very unlikely, just given the way crimes are prosecuted and treated in South Africa in general.
Okay, thank you. Well, we've reached the hour, and thank you both, Andrey and Ridwaan, for your excellent presentations, for keeping us to time. Thank you to those of you who sent questions in. I hope that the answers were useful for you. Please do send individual questions in if you want to any one of the three of us. As I say, the webinar is being recorded. It should be available from our website within the next week or so. Do visit our website to see what future webinars we may be doing here at Bristows. And please, by all means, go to my fellow panelists, Andrey and Ridwaan, if you have specific questions that they can help you with. So from me here at Bristows, thank you on behalf of my co-speakers, and we look forward to being with you on another occasion. Thank you. Bye-bye.
Thank you, Robert. Bye all.